Alright, peeps, quite literally, the fate of democracy is on the docket this October. It was recently reported that the United States Supreme Court will hear a case in October called Moore v. Harper. The issue of this case is a notion called independent state legislature doctrine, which holds that state legislatures have absolute power to regulate federal elections without fear of interference from state courts and judicial review and state governors and their veto. And since 19 red states have already enacted sweeping restrictive changes to their voting laws after the GOP's defeat in 2020, and Republicans control 30 out of 50 state legislatures in total, the consequences of this case cannot be overstated. It will likely be more impactful to everyday Americans than the Dobbs decision that overturned Roe v. Wade. The origins of Moore v. Harper span about a decade and go back to a series of legal battles between Republicans in the North Carolina state legislature, Democrats in the North Carolina state legislature, and North Carolina state courts. You see, historically speaking, North Carolina has been fairly evenly divided between Republicans and Democrats. In fact, prior to 2011, 7 of the state's 13 voting districts favored Democrats, and the remaining 6 favored Republicans. But following the 2010 U.S. Census, new voting maps were drawn that favored Republicans in 9 out of the 13 state voting districts, upsetting the balance of power. Legal challenges ensued on the basis that these maps violated the 1965 Voting Rights Act through racial gerrymandering. Consequently, in 2017, the U.S. Supreme Court affirmed a lower court ruling that struck these new gerrymandered maps down. But new maps, still heavily favoring Republicans, were drawn and upheld by a district court. Once again, legal challenges brought these gerrymandered maps before the U.S. Supreme Court, but this time, the Republican majority upheld the maps and said that the responsibility of curbing excessive partisan gerrymandering was the responsibility of states and Congress, not the courts. In terms of more recent history, after the 2020 U.S. Census, North Carolina gained 1 additional seat in the U.S. House of Representatives. And so yet again, the Republican-controlled state assembly drew new voting maps that favored Republicans in 10 out of the now 14 voting districts. And once again, these maps were challenged on the basis of racial and partisan gerrymandering and were struck down as unconstitutional by the North Carolina State Supreme Court. Now, in response, Republican legislators in North Carolina appealed to the U.S. Supreme Court to impose a temporary stay of the state Supreme Court's decision. Unfortunately for them, the U.S. Supreme Court declined to hear the case in March, despite a dissent from the conservative justices. In the end, this prompted Republican legislators in North Carolina to file a formal writ of certiorari to the U.S. Supreme Court, which granted it on June 30th, 2022. Which means that Moore v. Harper will be heard by the U.S. Supreme Court probably in October. So, Moore v. Harper, to be heard in October and likely to be ruled on sometime in early 2023, will ultimately settle the question of independent state legislature doctrine. But what the hell is independent state legislature doctrine, and what's it based on? Well, as the name suggests, independent state legislature doctrine is a conservative notion that state legislatures have absolute power to regulate federal elections without the threat of interference of state court judicial review or state governor veto. A blank check instead of checks and balances. The purported basis for this theory is the Elections Clause of Article 1 of the U.S. Constitution, which says, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof." I had to read that off a notepad because I wanted to make sure I nailed it verbatim. The problem is, according to a plethora of constitutional and legal scholars, constitutional references to state legislatures have pretty much always been interpreted as referring to entities created and constrained by their state constitutions. I mean, just think about it for a second. Take the U.S. Constitution, the supreme law of this country, bar none. The U.S. Constitution overrides federal statutes and federal law, state statutes, and yes, even state constitutions. But no sane, good faith actor would ever assume that when Article 1 of the U.S. Constitution empowers Congress to make decisions about the purse, that Congress could do so without obeying the U.S. Constitution. Or when Article 2 empowers the President to be Commander-in-Chief of the U.S. military, that the President is authorized to make decisions that defy the U.S. Constitution. Or hell, even Article 3 of the U.S. Constitution, which concerns the U.S. Supreme Court. No one would assume that the powers granted to the U.S. Supreme Court are powers that can override the U.S. Constitution. The Constitution is intended to be supreme above all else. And on a state level, that logic also applies. The branches of state government are and must be subordinate to that state's constitution. And North Carolina's own state constitution, drafted by its state legislature, along with a number of state statutes, have empowered North Carolina state courts to review and potentially overturn bad election legislation, including improper voting maps. Ultimately, conservatives arguing for independent state legislature doctrine are asserting that state legislatures are not subordinate to their own state constitutions and are free to be renegade and all-powerful arbiters of federal elections without fear of judicial review or governor veto, without fear, in other words, of checks and balances. So why is this so dangerous, and why earlier in the video did I say that this decision is potentially far more impactful and consequential than the Dobbs decision earlier this year, which overturned Roe v. Wade? Well, the logic is pretty straightforward. The U.S. Supreme Court is currently comprised of 9 justices, 6 of whom are conservative, meaning the highest court in the land has a 6-person regressively conservative supermajority. And at least 4 of those conservative justices have recently indicated sympathy for independent state legislature doctrine and an interest in having this issue decided by the U.S. Supreme Court. What do the other 2 conservative justices on the court, Chief Justice Robert, Justice Coney Barrett, have to say about this? Well, the jury's still out. But given the court's recent regressive history, including Dobbs, which overturned Roe v. Wade, I'm not really confident here. This could be a genuinely insurmountable election game changer delivered by the Supreme Court to the Republican Party, which again controls 30 out of 50 state legislatures, including many of the battleground states which ultimately determine presidential elections. Putting it bluntly, there's a damn good chance that the U.S. Supreme Court will cut the Republican Party a blank check to write voting maps and election laws however the hell they want to win all major elections, and state courts and state governors will be powerless to stop them. So what the hell can we do? Well, remember, this case will be heard in October, but probably won't be decided until early 2023. What happens in between those 2 dates? Ah yes, the November 2022 midterms. It is imperative that any sane, morally responsible eligible voter get out and vote in November, and vote blue, no matter who. At this point in time, even if President Biden were willing to take radical action to rein in this renegade court, which he's not, he's hampered in the Senate because at least 2 Democratic senators, Joe Manchin and Kyrsten Sinema, are unwilling to make any major changes to the U.S. Supreme Court. Our only hope is to expand Democratic majorities in the House and in the Senate. Let's get more Democratic senators in the Senate. Let's get more Democratic representatives in the House. Let's make it so that Sinema and Manchin can no longer hold us hostage. They're surpluses that we can ignore. That gives us more legislative options to rein in this court and ultimately the renegade party behind it. So as I said in the beginning, the fate of democracy is indeed on the docket this October, which means you must vote blue in November, no matter who.